It is now my honor to introduce today's graduation speaker, Jeffrey Toobin. If one were to identify the profession on which the strength of our democracy most directly rests, the legal profession would have to be at the top of the list. As de Tocqueville said, it's the foundation of our culture and our freedoms. But many observers would point to another vocation that is central to our democracy, the Fourth Estate. The sources of information are the springs from which democracy drinks, to quote Adlai Stevenson. Today's graduation speaker, a journalistic pioneer, has helped define the emerging field of legal journalism and thereby served to foster greater public understanding of our legal system. Some of the most debated legal issues in our society, the internal processes of Supreme Court decision-making, the legal maneuvering surrounding the 2000 presidential elections, the spectacle of Supreme Court nominations and confirmations, the trials of public figures such as O.J. Simpson and Michael Jackson are all now understood through the prism of our speaker's engaging books, articles, and commentary. Jeffrey Toobin was born the son of two journalists, Jerome Toobin, Bill Moyer's producer, and Marlene Sanders, the well-known female reporter and journalistic pioneer herself. While our speaker has wryly described his career as coming to terms with his genetic destiny, his parents advised him early on not to pursue journalism. It was a risky career, they said. Don't touch it. So he began what a journalist would probably view as a safer path, law. He attended law school in Cambridge, Massachusetts, for which we will forgive him this afternoon. And he loved the law. The 1L year, he has since observed, addresses the most profound issues in society: the obligation of citizens to one another, the role of government, the place of courts in sorting out conflict. Every law student should be fascinated by these questions, he has said. On the other hand, he could not escape his journalistic heritage. For example, he would later describe the cases in his first-year torts class as all like short stories. Unexpected calamities that befall the defenseless, exploding Coke bottles, railroad scales toppling over on passengers. Who could help but be fascinated by these vignettes or write about them? Not surprisingly, he took time during law school to freelance at the New Republic. It was in his blood. I should also note in passing that he developed a reputation in law school as quite a dancer. He was nicknamed Disco Toobin. As I said, he was not your typical law student. Upon graduation, he initially pursued a traditional legal path, clerking on the Second Circuit Court of Appeals and working as an assistant United States attorney. But it was then that the family DNA kicked in. As he later described it, I basically changed my career over a weekend, deciding to take a job at the New Yorker. Legal journalism did not really exist as a field at the moment. It was a huge risk, but the move turned out to be prescient. With the O.J. Simpson trial unfolding over the next year, public focus on the legal system skyrocketed. He ultimately moved to positions as senior legal analyst at ABC and CNN. Along the way, he helped to invent a field. He wrote 5 books that have blanketed the legal landscape. Some of these efforts brought legal texture and depth to spectacles such as the O.J. Simpson and Michael Jackson trials and the 2000 Bush v. Gore constitutional controversy. They were, as one reviewer observed, superb works of factual and legal analysis. But in his award-winning book about the Supreme Court, The Nine, he decided to create, as he later put it, a narrative about an institution rather than about an event. It was my hardest book to write, he later confessed. This was not only because he had to frame a story about an institution, but that institution, the Supreme Court, is itself the most secret of our branches of government. How does one make the court an engaging, readable tale while at the same time capturing its legal intricacy? He did it, and the result has been described as a masterpiece. He brings to life in public view the inner workings and thinking of the leaders of one branch of government as they map our constitutional heritage. Of course, the meaning of these stories and personalities will be debated endlessly. For example, our speaker has himself questioned our ability to predict what kind of justices Supreme Court nominees will be, or their future ability to sway their colleagues. Such work must walk a very fine line. At its best, however, public scrutiny can enliven and illuminate our profession and bring our democratic body closer to both understanding and holding accountable our legal norms. That is what our speaker has done. It therefore gives me great pleasure to introduce one of the country's distinguished legal journalists, as well as a pretty good disco dancer, Jeffrey Toobin.
Don't worry, no dancing. Dean Fitz, thank you so much, and thank you for inviting me. Thank you for listing me in the program as Jeffrey Toobin Esquire. I haven't seen that in years. It's really a great honor to be here and to celebrate with you. So let me add my congratulations to the class of 2010. Law school is hard. Law school takes a long time. It takes almost as long as college, and it's not as much fun. But you're done now, you've made it through, and you're off to the real world. God help you. Before you do anything else today, class of 2010, and those of you here, I hope you say thank you a lot. Say thank you to your parents. You should always say thank you to your parents, but especially today, and especially if they've helped pay for all a part of your adventure here at Penn. Say thank you to your friends, spouses, and significant others for putting up with you these past 3 years. There are few people in the world more self-absorbed than law students, although I suspect journalists are right up there. And my strong inclination is that more than once you have taxed the patience of those around you. So say thank you to them as well. I should say my own thank you. It is a special honor to be invited to speak here at Penn. I grew up in New York City, but my dad grew up in Philadelphia. In the way that parents bore their children, I cannot tell you how many times I heard about the charms of Breyer's ice cream, tasty cake, mustard on pretzels. And my dad went to Overbrook High School and Temple, but okay, that's good. It's not, I wouldn't say it's a rousing ovation, but it's good. But he revered Penn, and I think he'd be especially pleased to see me here today, especially just a few blocks away from the Curtis Institute, where he studied violin, not entirely successfully. So I'd just like to say to him that, Dad, you were certainly right about the tasty cakes. There really is no better food in the world. You are graduating into uncertain times. I work in cable news, so I'm comfortable making these blindingly obvious observations. But it is true. The recession is technically over, but times are lousy, especially in law firms. I'm glad many of your parents are here, but I hope not too many of you are moving back in with them. But times of uncertainty, times of change, that is something to embrace, as the Chinese proverbs have it, rather than something to fear. Let me give you one example from my own life. I suspect that many of you know me, if you know me, as a television legal analyst. Well, when I graduated from law school in 1986, I did not aspire to be a television legal analyst. I didn't because the job did not exist. There was no such thing as a television legal analyst, and for that, for better or worse, we have O.J. Simpson to thank. But I think the point is of broader application. Many of you will spend your careers in jobs and fields that do not even exist today. You will litigate cases, you will do deals on subjects and products that have not yet been invented. That thought is a little bit scary and a lot exciting. In my current reason, I have, for obvious reasons, been thinking a lot about the Supreme Court in recent days. Probably you have too. It's always exciting. When there's a vacancy on the court, we call these confirmation hearings the nerd Super Bowl. But this vacancy and this appointment has special significance to me. When I arrived at law school in 1984, I joined a first-year study group with a few of my friends. I'm sure many of you did too. The poor people in my study group were me, Tony Herman, Gail Horowitz, and Elena Kagan. Life takes strange turns. who would have thought all those years ago, as we struggled to understand torts, property, contracts, that one of us would go on to cover the Michael Jackson case? It's just a remarkable thought. The court is a peculiar institution. It is at once very public and very private. I'm often asked, who's my favorite justice? Well, I'm working on a new answer because it's been David Souter for a very long time. It is truly hard to imagine a more unusual figure than David Souter. This is a person in the late 20th and early 21st century who did not have a computer, who did not have a cell phone, who did not have an answering machine on his phone, who did not like electric light, who used to move his chair around his chambers over the course of the day to catch sunlight. But he was someone who really got it, who understood what it was like to be, what it meant to be a Supreme Court justice. And he also understood the weird public and private nature of the job, and sometimes he even had a little fun with it. I'll give you an example. Now, for reasons that remain obscure, to this day, David Souter and Stephen Breyer are frequently mistaken for each other. Now, if you know what they look like, they don't really look anything alike, but it happens to both of them all the time. And one time, not too many years ago, Justice Souter, as he often did, was driving from his home in Washington to his home in New Hampshire, and he stopped in a little restaurant to get something to eat. And a couple came up to him, and the guy said, "I know you. You're on the Supreme Court, right?" He said, "Yes." He says, "You're Stephen Breyer, right?" And Souter didn't want to embarrass the fellow in front of his wife, so he said, "Yes, I'm Stephen Breyer." And they chatted for a little while, but then he had a question that Souter wasn't ready for. He said, "So, Justice Breyer, what's the best thing about being on the Supreme Court?" He paused for a minute, and he said, "I have to say it's the privilege of serving with David Souter." Now, how can you not love an institution? Well, that's possible. The court is at a crucial moment in its history, and when I suggested the people for you to thank today, I left out one important group. You should say thank you to the people at Penn, the faculty, the staff, and everyone who worked so hard so you could come to this day. Now, those of us who've been through law school tend to talk about it the same way. We talk about the friends we made, we talk about our extracurricular activities, whether they were student publications, legal aid, working really hard on our NCAA basketball pools. But in thinking back, I think there is something we often neglect when we talk about our law school experience, and that's our classes, the academic experience. Speaking just for myself, I loved the academic experience of law school. The richest educational experience of my life was absorbing torts and con law and local government law at the feet of wonderful teachers. You all are fortunate to have gone to a great law school, and I know you had great teachers too. And because you had great teachers, I think you have a special responsibility to think and talk about the Supreme Court. Not just those of you who go into litigation or public interest work, but all of you, because all of us have a stake in the court. Of course, I don't want to tell you what to think about the court, except to say that I do think you should think about it. This is especially true now when we're about to have a confirmation hearing. These are political events, of course, and they are mostly designed to persuade rather than to educate. They really are more like trials than hearings. The opposition party is the prosecution, and the president's party is the defense. You can see it in the questioning. Patrick Leahy, the chairman of the Judiciary Committee, will be doing the direct examination, and Jeff Sessions, the ranking Republican, will be doing cross. But you, as new lawyers, have a special responsibility to serve as a sort of truth squad for what's going on in this committee. If the past is any indication, you, as Penn graduates, will be leaders in the legal community and in the broader world. People will look for you for help for what's going on. Now, just for example, there will be a lot of talk this year about judicial activism. Well, what is judicial activism? Well, a former professor at the University of Chicago named Barack Obama gave a pretty good definition the other day on Air Force One. He said, "An activist judge was somebody who ignored the will of Congress, ignored democratic processes, and tried to impose judicial solutions on problems instead of letting the process work itself through politically." Now, this accusation, judicial activism, has usually been made against liberals, and with some justification. Roe v. Wade is a classic activist decision. It said that state legislatures, the people's representatives, could no longer pass laws which ban abortion. Miranda is an activist decision. The Supreme Court simply announced that all criminal suspects had to be advised of their rights, despite what police departments may have wanted to do. Indeed, judicial activism has largely been thought of as a liberal thing. It's what liberals do on the Supreme Court, right? Well, not so fast. What we are seeing now on the court is conservative judicial activism. Local elected officials in Seattle and Louisville created a complex and nuanced strategy to achieve racial diversity in their schools. Well, in 2007, in a decision written by Chief Justice Roberts, the court overruled those plans. The elected city council of the District of Columbia passed a strict gun control law. In 2008, in a decision by Justice Scalia, the court vetoed it. Most notoriously, Congress passed the McCain-Feingold campaign finance bill, which President Bush signed into law. Earlier this year, in a decision by Justice Kennedy, the court eviscerated that legislation and decreed that corporations have the right to spend unlimited funds to spend on the candidates of their choice. It's all judicial activism, except it's conservative judicial activism. Consider another familiar concept of law, states' rights, or federalism. This idea is very much associated with conservatives. During the 60s, states' rights was the cry of people in the South who didn't want the federal government's who wanted to fight the federal government's demands for civil rights for African Americans. During the 80s, the great conservative Chief Justice William Rehnquist was an advocate for states' rights, to fight back against what he thought was Washington's heavy hand. But again, federalism is not necessarily conservative. Blue states fight back against the federal government too. California has made medical marijuana legal against the will of Washington. Several states have liberalized laws regarding assisted suicide. The struggle for same-sex marriage has mostly been waged at the state level. All liberal causes. Don't let anyone say that federalism is always conservative or always liberal. Same thing with free speech. This used to be a liberal cause, more or less exclusively. The great Holmes and Brandeis dissents around the turn of the last century were all about the rights of the politically unpopular, the outsiders, who were being punished for what they believed. But that too has changed in recent years. Freedom of speech is not a liberal cause exclusively anymore. Many feminists believe that regulating pornography is a matter of women's rights as well as free speech. The right to protest outside an abortion clinic, is that a liberal or conservative cause? And look at Citizens United itself, the case about political advertising. That was a case where the court embraced the right to free speech of corporations. Again, the categories are scrambled. Now, I don't want to tell you what to think about judicial activism, about federalism, or free speech, but I do think you need to think about them. The oldest cliche about law school happens to be true. You learn to think like a lawyer. I happen to think that's a good thing, to think analytically, critically, skeptically about ideas in the world. When you think like a lawyer, you think like an informed and engaged citizen, and that's what I hope you'll be. Congratulations again, and don't forget those thank yous.